So the first question that comes is, what is a contract? The contract and a contract is one of the most essential documents in an agreement or in a business. Now, there are two aspects in a contract. First, there is an agreement and there is a legal enforceability. But then there is a difference. Now you can ask that what is the difference between an agreement and a contract? So a contract is different than agreement is that it has legal enforceability, whereas agreement is simply an offer plus acceptance. For example, if two friends want to go out for a movie, it is a simple, somebody asked and the other friend said, okay, fine, I'm all ready for the movie. That is an agreement. But you cannot enforce or you cannot take your friend to court if you want to make him go out for a movie. And here is the difference between a contract and an agreement. So a contract has legal enforceability. Now, there are certain essential elements in a contract. In fact, there are a number of things which are very essential for any agreement to become a contract. And as it is said, that all contracts are agreement, but all agreement is not a contract. So the first essential element is an offer, of course, as we discussed before, and then an acceptance. Third, an intention to create legal relations. Means right from the word go, you need to have that intention that if it is not done, we can take the other party to court. The fourth aspect is consideration. Now, consideration is the thing for which you are making a contract. For example, I want to buy a car from my friend and I offer 50,000 rupees for that. Now my friend says, okay, fine, I will take 50,000 rupees for a car, for the car. So here, there's an offer to buy his car, the acceptance from my friend that, okay, I'm gonna, take 40,000 rupees. So the consideration for myself, for me, is the car, and for my friend is 50,000 or 40,000 rupees. So consideration is that aspect for which the contract is made. And it is said that no consideration, no contract. Then capacity of parties or competency of the parties for the contract. Now, competence of the parties is that a person should be above 18 years of age. He should be competent enough to contract. Means he should not be a lunatic. He should not be drunk. He should he should be of a sound mind. Then comes free consent. Now, free consent means that the consent of the party should be freely given. It should not be under coercion. That if you show a gunpoint and you say that you have to sell the car to me, otherwise I'll shoot you. And then the person obviously is scared and he says that, okay, fine, I'm selling the car. This is not free consent. Okay, then it should be for a lawful object. Means if you are making a contract, you have to have something legally done. You cannot, two people, A and B, they say, okay, let us forge a contract, let's make a contract and let's go and, break the ATMs and take out money. That is an illegal thing. Such kind of contracts are not enforceable in a court of law. Then comes writing and registration. Now, verbally, of course, the contracts can be there verbally, but generally it is accepted that it should be, written and registered. Now, there should be a certainty. That is the next point. Certainty of the contract means that it should be for a certain thing. It cannot be for an imaginary, fictitious thing that or that, okay, we will be doing this for infinite period of time. That is not certain. Then comes possibility of performance. Now, possibility of performance means that it should be done for that thing which can be possibly done. Now, that is, for example, two people make a contract, sign a contract that the other person has to find a treasure from his backyard. Now, that is an impossible thing. It may or may not happen. So that is not an essential aspect of a contract and not expressly declared as void. So any contract which is, expressly declared as void also cannot be considered as a contract. Things like, okay, so we were there at agreements expressly declared void. Now, some certain expressly declared void agreements are those agreements such as, agreements in restraint for marriage, immoral things, any for wager agreements. All these things are the expressly declared void contracts. Then we come to the two kinds or various kinds of contracts. Now, the first, basically, there are three broad categories. First is the void contract. Now, the void contracts, again, are those contracts which, as law says, are void ab initio, means right from the word go, they are void. For example, if you, make a contract with a minor, it is a void contract. A contract without consideration is a void contract. Then comes the voidable contract. Now, the voidable contracts are those contracts which can be made void, void by either parties. They can be, for example, two people sign a contract and there is some kind of a mistake, technical fault that can be made void, that can be made voidable. Or there is some kind of a mistake, there's some hidden fact. Those contracts are the voidable contracts. Then comes the illegal or unlawful contract. Now, the illegal or unlawful contracts are those contracts which, of course, as the name says, are not according to the law or what the law prescribes. Now the other contracts are the express contracts, the implied contracts, and the quasi contract. Now, again, express contracts, as the name suggests, are expressed and as something the way we've been discussing about. Then implied contract, you get on a bus, you buy a ticket, and means you have to pay, and then the driver or the bus has to take you to the destination. So it is an implied contract. So even if you're not signing a proper agreement, still it is a contract. Then comes the quasi contract or the quasi contract. Now, the quasi contract are those contracts which are which are contracts in the manner. I'll give an example. For example, if you find somebody's wallet, it is your duty to go and hand it over to the police. So this, even though you do not know that person, but it is your responsibility to hand over that wallet. You simply cannot take it that, and keep it that, okay, I found this wallet, so it is all mine. That is a quasi contract. So even though there are no, kind of two people and signing and consideration, yet they are it is a proper, it is a contract. Okay. Now we come to offer and acceptance. The offer or proposal. The Contract Act uses the term proposal. It defines proposal as when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that another to such the act of abstinence it is to make a proposal. Means Now it is a technical term. It's a little complicated, but simply it means that when you are showing your willingness to do something or not to do something with an objective of getting the other person's yes or assent, that is called a proposal. Now, legal rules as to offer may be express or implied. Offer must be capable of giving rise to legal consequence and creating legal relations. The terms of offer must be certain and definite. The terms may not be vague or loose. An invitation to place offer is not an offer. It is a very, very important thing. The terms of offer must be certain and definite. The terms must not be vague or loose. Means when you are offering, when you are proposing something, or when you are putting your offer, the terms should be clear. There should have a clarity in when you are offering. Then the invitation to place offer is not an offer. Means you are saying that, okay, I'll be putting an offer or something like that. Then it is not. It has to be very, very specific and clear cut. An offer may be general or specific. Offer must not contain a term the non-compliance of which would amount to acceptance. Means that, okay, if you do not say yes, if you do not say no, it means it is a yes. That is not an offer. Two identical cross offers do not make a contract. Now we come to the term acceptance. Legally, the term acceptance is defined as when the person to whom proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So it means that unless and until it is accepted, a proposal is accepted, it cannot become a promise. So it has to be accepted to become a promise. Now, there are certain legal rules regarding to valid acceptance. Acceptance must be given only by the person to whom the offer is made. It should not be given to somebody else, but only specifically to the person to whom we want to make an offer. Now, acceptance must be absolute and unqualified. Means that it should not have any if or any clause attached to it. Acceptance must be communicated in some usual or reasonable manner unless the manner is prescribed in the offer itself. So it means that acceptance should be either given in the manner which is prescribed in the contract or in a general or the usual reasonable manner. Acceptance must be made within reasonable time or before the offer is terminated. If somebody says that I have to you please give your assent in a particular time period, we have to follow that time period. Now we come to the contingent contract. The Contract Act defines a contingent contract as a contract to do or not to do something if some event collateral to such contract does or does not happen. Means a contract may, number one, be absolute or unconditional, or conditional or contingent. So such as a contract of insurance, of indemnity, and contracts of guarantee are all contingent contracts. Or in simple words, it is something to do or not to do something if some event happens or does not happen. Now, performance and discharge of contract. Discharge by performance means performance may be actual performance or, number two, accepted performance, or it is also called tender. Now, the second aspect of performance and discharge of contract is discharge by mutual consent or agreement. Means two parties mutually agree that we have to, discharge this contract or agreement. Third is discharge by subsequent or supervening impossibility or illegality. For example, there are contracts which are illegal. It is impossible for the contract to finish off. So then it is discharged. Then by lapse of time. Means the time limit has crossed and then it is no use doing it. Discharged by operation of law, when actually the law, because there's a change of law or something happens, where the law takes its action and the contract cannot be done. Then discharge by breach of contract. Now, that may be of two kinds. Number one, actual breach, and then the anticipatory breach. Now, quasi-contract. Now, as we discussed it before, quasi-contracts are very, very important in a contract act. So every contract is the result of an agreement which is based on an offer made by one person and acceptance by another person. In some cases, there is no offer, no acceptance, and in fact, no agreement as such at all. And yet, in the eyes of law, there exists a contract between two parties binding them under contractual obligations. In other words, law creates a contractual relation between two parties who never had an intention of entering into contract with each other. Such contracts are called quasi-contract. There are certain obligations, that arising out of quasi-contracts. Number one, claim for necessaries supplied to a person incapable of contracting on his account. Reimbursement of person paying money dues by another in payment of which he is interested. Third, obligation of persons enjoying benefit of non-gratuitous act. Then responsibility of finder of goods, liability of person to whom money is paid or thing delivered by mistake or under coercion. So simply, these are those contracts where two people had no intention, per se of getting into a proper contract. Yet it is a responsibility of the persons to, comply with the situation. Then comes remedies for breach of contract. Number one, rescission of contract. Second is the suit for damages. Suit upon quantum meruit. Quantum meruit means as much as is done. Then suit for specific performance of the contract and suit for injunction. That's all for the contract.